An 18-year-old defendant walks into court facing a burglary charge that could leave a permanent mark on his future. At an age when most people are just starting their adult lives, he's standing before a judge with everything on the line. The prosecution has already made its decision, and the courtroom is waiting to see what happens next. But as the hearing unfolds, the judge begins asking questions that reveal a much bigger story. What follows is a surprising courtroom moment that could give this young defendant an opportunity most people never receive. Will he walk away with a criminal conviction, or will the court offer him a rare second chance to turn his life around? And if he does get that chance, can he meet the strict conditions that come with it? Stay with us until the end to hear the judge's warning, the conditions of the deal, and why one mistake could still send him to jail.
All right, ma'am, your Trinity Bell. Yes. And this is cause number 25 DCCR 1381. I'm going to reset, just a normal reset to give you guys time to get it filed down in misdemeanor court, get that taken care of. If everything gets taken care of and you go to court down there, then you probably won't have to come back to this court date. Your case will be dismissed. Unless you hear otherwise, though, plan on being back here unless Ms. Holmes or your bondsman tells you you don't have to, okay?
Yes.
All right.
And they had one, Ms. Bell has been wearing a GPS ankle monitor for quite some time, and we were wondering if the court would allow her to have it removed or.
Let me look real quick. I don't know that I have any notes on any issues.
Is your prosecutor down?
Mr. Smith.
Judge, we're not opposed to it.
All right, so Ms. Bell, I'm going to remove that condition of your bond that you have to have. Well, actually, let me make sure first that it's a condition of the bond and not of the bondsman.
Oh,
Because if it's their condition, that's up to them. If it was the court's condition, I can change it. And I forget to look at that sometimes, and they get very mad at me. Let's see if I can figure this out.
what we would do is probably just get funds from those and then just use this. I mean, they don't really do it, so she can just ask for a poster. She can see. It's a short and sweet person. That's it. Yeah, let her.
I don't see that I don't see it notated on the magistrate's warnings.
What price to the judge?
Yeah. Okay.
Yeah, good. Still trying.
There we go. Right there where it says bonds. It's there. It's mine. It's a court bond. Okay. So then, our court condition. Have you been going to, did you go get an assessment? Have you been going to Spindletop like you were supposed to?
No, ma'am, I lost my job, so I don't have any insurance or anything anymore.
Well, that's the nice thing about Spindletop is you don't have to have it.
Okay. Well, I did make an appointment for it.
Okay, so that was also a condition of your bond, that was set. And so it's very important that you still follow through with that. So even if it's going to be misdemeanor case, you need to go get that assessment done, call and make your appointment so that you can get that done before we take care of that other stuff, okay? But I will remove the GPS monitoring device condition today. Ms. Holmes can tell you, y'all can talk about how to do the Spindletop thing, but I'll remove the bond condition of the GPS device today. All right? Okay, stay in touch with Ms. Holmes.
Yes.
Good morning. Are you Aston Hayward? And will your client make the formal reading of the indictment?
Yes.
What?
Class A attempted.
All right, Mr. Hayward, in cause number 25 DCCR 1346, the state has elected to proceed on the lesser included offense of a Class A misdemeanor, attempted burglary of a building from August 29th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred probation. There would not be a fine, but there would be restitution in the amount of $2,620. Is that your understanding? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hayward's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 2 years. You're ordered to follow all of rules and conditions of probation, and you're ordered to pay that restitution in the amount of $2,620. If you do everything that you're supposed to on this probation, get the restitution paid off, this is a great opportunity because you don't have a conviction on your record. And if you satisfactorily complete the probation, at the end, the case gets dismissed. You'll never have the conviction.
Yes.
The other side of that, though, is if you violate any condition of your probation, then you can be brought back into court, found guilty of the offense, and go to the Jefferson County Jail for up to 1 year. Do you understand? So $2,600 is a lot to pay in 2 years. How old are you? 8. So you're very young. It's very important that you make payments on that every single month, even if it's a little bit, because it'll add up. All right. So some people think, well, I'm going to get a better job, or I'll sell this, or I'll get my tax refund and I'm going to wait to pay it. And then all of a sudden you're at the end of your probation and you haven't paid it. If you come back at the end of your probation, you can have done everything else right and not paid that money. And if I find that you could have paid it, then you could still be revoked and go to jail even after 2 years. Do you understand?
Yes, ma'am.
Also want at least half of whatever he pays to go to restitution in the beginning. Okay. So that way I want them to get paid, the victim to get their money and get paid for what happened. Okay. That's very important to me. So I'm going to hand you now the trial court certification that shows this was an agreement that I followed. And so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation is sitting at that desk right there. She's going to call you up to her desk when she's ready to go over your paperwork. All right. Good luck to you, sir. Thank you.
This case shows how the justice system can balance accountability with opportunity. The defendant avoided an immediate conviction, but the judge made one thing very clear: a second chance is not a free pass. Every condition must be followed, every payment must be made, and any violation could bring him right back into court. Now we want to hear from you. Do you think the judge made the right decision? Should young first-time offenders be given opportunities like this, or should the consequences be tougher? Let us know your thoughts in the comments below. If you enjoy real courtroom footage, judge reactions, legal cases, and the most interesting moments from the justice system, make sure to subscribe to the channel and turn on notifications. We upload new courtroom stories regularly, and you won't want to miss the next case where one decision could change a defendant's life forever. Thanks for watching, and we'll see you in the next courtroom case.